Hello, this lecture will explain some of the strategies states and non-state actors use to instigate compliance with international law by using cooperative strategies or positive incentives, including peer review processes developed in the context of the OSCE, the African Union, and the United Nations. We will also look at confidence building measures attempted as useful mechanisms to instigate compliance in multiple contexts. Remember the general structure we are following in exploring strategies for the enforcement of international law. We have first outlined what I have called confrontational measures, although I have left the topic of the Security Council and the General Assembly role in this field for later. I am now addressing what I have categorized as fitting cooperative strategies to instigate compliance. I have also made the point that enforcement is related to the topic of international responsibility and the topic of settlement of international disputes. After all, when a state breaches international law, the injured states can claim responsibility and activate enforcement measures using confrontational or cooperative approaches. Among those of confrontational character, I have listed legal settlement of dispute mechanisms. Injured states by a breach of international law resort to diplomatic settlement of dispute mechanisms to claim their rights. They will be using a more cooperative approach to enforcement. I have also explained that technical assistance, foreign aid, can be used to promote the improvement of compliance with international law. When no conditions are attached to these programs, to this aid, they fit the category of cooperative strategies aiming at improving compliance. Technical cooperation is particularly used in the field of development and human rights compliance. Few minutes, I will focus on two types of measures frequently present in international relations to promote enforcement of international law using what I have called cooperative strategies, peer review processes, and confidence building measures. I have called peer review processes consist of states agreeing to monitor each other's behavior according to a set of international rules in a particular field. This kind of processes has been institutionalized within the Organization for the Security and Cooperation in Europe, the African Union, and the United Nations, as we will see now. Act of Helsinki, signed in 1975 between 33 European states plus the US and Canada, is one of the most significant examples where a change from a confrontational approach to a cooperative approach has been considered best at ensuring the compliance of international law. After 2 years of negotiations in the context of what was then an annual conference between European states, the so-called Conference for the Security and Cooperation in Europe, states signatories of the Helsinki Act agreed on this non-binding document intended to mitigate the tensions between the communist and the capitalist group within the context of the Cold War. They basically agreed to respect each other's borders and different economic and political systems without resorting to threats or the use of armed force or any other form of interference in the internal affairs of each other. The respect for human rights was also a significant element of the Act. The implementation of this agreement was mainly left in the hands of the intergovernmental process of the annual conference. This is why I have included it as a peer review mechanism. This form of cooperation became institutionalized further with the creation of the Organization for the Security and Cooperation in Europe in 1990, although the formal change of name to organization did not happen until 1994. The African Peer Review Mechanism was created in 2002 as a specialized agency of the African Union. 40 states at the moment of recording participate in this process, and they do so voluntarily. The peer review works as follows. It is based on the self-assessment of the state who is under review every 4 years, and based on that self-assessment, other states of the APRM assess that state on every area of self-government, of good governance. This way of operating has been replicated, as we'll see immediately, in the field of human rights at United Nations level. Since 2008, the United Nations Periodic Review emulates the African system. The main difference is that the UPR, the Universal Periodic Review, is open to all states, and the monitoring focuses on human rights compliance and not on good governance. I have written praising this mechanism for what it has already achieved and what I think its potential, but please be aware that there is quite a lot of criticism towards this UPR, Universal Periodic Review, and it has been described as a mutual admiration society. There is a lack of trust from NGOs, civil society at large, and even states about other states' ability to self-monitor and to monitor other states beyond political alliances. I actually believe there is a place for both kinds of approaches to human rights compliance and any other kind of compliance with international law, more confrontational ones and more cooperative approaches. And at the same time, this particular one has demonstrated that if you get the right mechanism, you might be able to engage all the states of the world. In fact, it's the only one that exists at the moment where absolutely every state has cooperated with 100%. If you want to know more about it, there's plenty of information, plenty of data collected. In the few years it has been in operation, and you can find it in the website of the Office of the High Commissioner for Human Rights, or on the website that I would prefer actually of an NGO called UPR Info. Let's focus now on the last type of cooperative measures I wanted to introduce to you, confidence building measures. Indicates confidence building measures can be used in every area that is affected, undermined by the mistrust between two parties in international relations. Sometimes they are not even aimed at other states, but to non-state actors and the general population. For instance, the World Trade Organization has tried to become a more transparent body since it faced huge protests against its functioning in 1999. We are referring to those confidence-building measures that attempt to improve not only the relationship between two subjects of international law, but also to promote its compliance by cooperation. They normally involve sharing information and joint activities. For instance, a typical example would be the acceptance of observers from another country or from an international organization in election processes, or exchange of scholars, or joint cultural activities, etc. Because the exchange of information about military operations is, for obvious reasons, particularly sensitive, some of the confidence-building measures focusing in this field tend to get more prominence and attention than others. The Organization for the Security and Cooperation in Europe has devoted a significant amount of its activities to this kind of actions under what it calls confidence and security building measures. You can find quite a bit of information about this on its own website. The potential and limitations of confidence building measures can be illustrated through the lenses of the protracted conflict between India and Pakistan over the territory of Kashmir. So these two countries are particularly reticent to accept the intervention of a third party to mediate in the conflict. Therefore, the use of bilateral measures between them has been key to avoid a full-blown military conflict between two nuclear powers. In particular, for decades, they have used successfully a wide range of confidence-building measures. And I'm saying successfully because they have avoided this escalation to military conflict between them, which has been feared on several occasions. However, it's also a limited success because, as you all know, this has not been, they haven't resolved the main issue of the territorial boundaries, but also the actual mistrust that continues to exist between the two countries.